former President Zuma was assured by one of the ANC members on the panel that he need not worry, because the expropriation bill makes it possible to expropriate without compensation for property of all kinds going back to 1652.
What is the state of play with expropriation without compensation? So much legislation moving around, everything else in the world at the moment, especially in terms of foreign policy. It's difficult always to keep track of exactly where the government's agenda is at the moment, but expropriation without compensation remains firmly on the agenda, even now as the election cycle for 2024 heats up. Joining me to discuss expropriation, specifically the expropriation bill, is Dr. Anthea Jeffery from the Institute of Race Relations. Anthea, thank you very much for your time at the CRA YouTube channel this week. Just to start off with an overview of the expropriation bill, where it is in the process at the moment, and in your view, some of the biggest problems with the bill. One can sort of identify, I think, at least three, and probably many more, but three of the major ones that you've identified with the bill itself.
Yeah, nice to be with you, Chris. Thank you for the invitation. And in terms of where the bill is now, it's passed the National Assembly, as I think many people will be aware, and is before the National Council of Provinces, our upper house. And the National Council of Provinces recently convened a couple of oral presentations on the bill, where organizations or individuals who made written submissions on it were given the chance to address the Select Committee and highlight their particular concerns. So the IRR was one of the organizations invited to make an oral presentation. And this meeting kicked off with former President Zuma being the first person invited to make an oral presentation. And it was interesting to hear what he had to say, which in essence was a complaint that the ANC had not changed the constitution, because he found it unacceptable that expropriation would then be limited to property which had been taken after 1913. This refers to a date in the constitution which says that claims for restitution can only be lodged in relation to property of which people were dispossessed after the Land Act came into force in 1913. In any event, former President Zuma was assured by one of the ANC members on the panel that he need not worry, because the expropriation bill makes it possible to expropriate without compensation for property of all kinds going back to 1652. So the implication one felt was that there's really a large agenda still there. To some extent, we're often told that people shouldn't worry too much about the expropriation bill, that it will be sparingly used. Certainly for some people, I think that is within the ANC, that is not the intention. So where we are is also that some small changes have been made to the wording of the bill as it's come before the National Council of Provinces, but those changes are really too insignificant to make any real difference to the danger that it poses. And the three big risks are still the same essentially as before, that the bill provides for nil compensation, in essence for unused or abandoned land, is the way that the ANC likes to put it. But in fact, it's an open list that's being provided in the bill of the circumstances in which nil compensation could apply. So nobody knows how far it could extend. And there's certainly a risk that land will be deemed to have been abandoned where people have lost control of it, perhaps because a building has been hijacked in a CBD, or because there's been a land invasion, as is increasingly the case in many municipalities. And if anything, there could be an incentive towards land invasions, because once the owner has lost control, then the property can be expropriated for nil compensation. And even where the compensation is more than zero, it's very often going to be far less than market value. It's going to be inadequate. That is the whole purpose of the bill. And people will unfortunately have very little opportunity to object because of the way in which the procedures under the expropriation bill are really skewed in favor of the state and against the expropriated owner. And perhaps the key example is in terms of the right to a prior court order. According to the bill, if the state wants to implement temporary expropriation. In other words, it wants to take over the use of property for a particular period because of some urgent need. Then it must generally get a prior court order before the temporary expropriation can proceed. Undoubtedly, if it wants to extend a temporary expropriation from 12 to 18 months, it must also get a prior court order authorizing this. But when it comes to the far more serious blow to property rights of a permanent expropriation, there the bill does not allow for a prior court order. On the contrary, it makes it very easy for an expropriating authority, say a municipality, to take ownership of the property very quickly. So according to the bill, after certain preliminary steps have been concluded, a notice of expropriation may be served on the owner. And that notice will state the date of expropriation. In other words, the date when ownership will automatically be transferred from the owner to the state. And the bill still has no provisions on time, which would prevent that happening very quickly. On the contrary, the bill says that ownership can't go to the state before the notice of expropriation has been served. That's really the only limit. So if the notice of expropriation is served on the 1st of November, you can't have ownership flowing to the state on the 31st of October, but you certainly can have it flowing on the 2nd of November, which is the day after. And this kind of very rapid transfer of ownership seems to be what the government has in mind. And this emerges from a public hearing that was held in the Western Cape. All the different provinces held public hearings. And this particular one was attended by a colleague from the IR, Gabriel Krauser, and also by one Johannes Lakala of the Department of Public Works and Infrastructure, who made it very clear that in the department's view, as soon as a notice of expropriation is served, ownership will automatically pass to the state. Now, I think Mr. Lakala's interpretation is wrong, if only because one tiny change that's been made to the bill talks about the need for a future date of expropriation to be set out in the notice. But a future date could indeed be the 2nd of November in the example that I cited. The notice comes on the 1st of November. It could identify a future date of expropriation as being the 2nd of November. So there's no real advance there. And the risk this creates is that for many people who've already lost ownership long before they can get any compensation, it just makes it too risky and too difficult to go to court to challenge the validity of the expropriation or whether the compensation is really just and equitable. In theory, the expropriated owner has 180 days from the date of the service of the expropriation to go to court. But if owners are already reeling from the loss of their property and they're worried that they might end up having to pay the costs of the state, then most people are just going to find that this is an empty right, that they can't take advantage of it because they can't risk the costs of litigation and they can't risk having an adverse costs order. So in many instances, even though a challenge ought theoretically to be mounted, ought in fairness to be mounted, it won't happen. And that's another reason why the bill should make it very clear that it's the state that must go to court first, that it must obtain a court order confirming that the expropriation is valid, that it's really in the public interest, and that the amount of compensation is really just and equitable. And only thereafter should it be able to issue a notice of expropriation. And this is a point that the IRR and others have been making very strongly. We hope that we will prevail, and that in the end, if the government does not heed the fairness of what we say, plus the fact that this is the only constitutional way to proceed, then a challenge must be brought to the validity of the bill. There are good grounds to believe that the Constitution is on the side of those who say the state must first go to court, get the authority of a court order before it proceeds with an expropriation.
So even assuming that let's assume that the bill is not signed into law before the elections next year, Anthea, given the many things on the legislative agenda for the government, including the NHI bill, of course. Are there forms of expropriation already occurring where maybe through other avenues the state is trying to pursue this agenda without quote unquote waiting for the Expropriation Bill, for example?
We have an existing Expropriation Act, one which was adopted in 1975, which the government is seeking to replace. But it has, of course, been using expropriation powers in the meantime under that existing act. So one example which came to my attention a little while ago, which is relevant too to the content of the new bill, involved the plight of one Becky Dlamini, who owns 7,000 hectares of land in the Graatville area, which the municipality supposedly expropriated by serving a notice on him. But he never received the notice. And he discovered to his dismay about a year later that the property had already been registered in the name of the municipality. And then he'd had to try and get to court to fight against this. And it was very difficult. The municipality declined to provide him with a duplicate copy of the notice. And it took really a couple of years before he could prove that this expropriation notice had supposedly been served on him. And in the end, the court said that he was out of time and that no relief was possible, which makes it absolutely vital that people should know when notice of expropriation has been served. And yet the bill makes it possible for such a notice to be served by registered post. And this in the context where the South African Post Office is closing branches all over the place, and where its capacity to operate efficiently and make sure that even a registered item does reach the recipient is pretty doubtful. It's another basis on which the bill can be challenged for unfairness, for resorting to procedures that really will make it very difficult for the expropriated owner to know what is happening and to be able to defend their rights. And then I think the other thing that we mustn't forget about with the bill is the risk of custodial takings. I know most people concentrate only on the risk of expropriation, but what the bill also contains is a definition of expropriation, which has deliberately been made so narrow, contrary to the normal international law understanding of what the word means, that the state could take custodianship of land and then claim this is not an expropriation at all. So there's no question of us having to pay compensation for this taking. And we know that the ANC is keen on a custodial taking. It's already taken custodianship of water resources and of mineral resources. It would like to take custodianship of land as well, as we saw in 2014 when it put forward a bill under which all agricultural land would have been vested in the custodianship of the then Department of Agriculture and Land Reform. So that bill didn't proceed, but after the expropriation bill is adopted, if it goes through in its present form with this definition, we could find a new bill similar to the 2014 one being brought forward once again. And then vast swathes of land could be taken into the custodianship of the state with no compensation being paid. Owners wouldn't necessarily have to vacate their land, but they, instead of being owners, would become tenants of the state. And in either extending or renewing leases, the state could impose increasingly onerous conditions, as we've seen in the mining sphere, for example, where BEE requirements have steadily been ratcheted up, and as we've recently seen also in the water sphere, where large users of water are now being told that if they want to retain water usage, they must have 75% Black ownership. So it's a strategy to give the state control and then allow it slowly to increase the pressures that it places on former owners, now effectively people who always need its permission to continue using the resource which it has taken into its own control.
Thank you very much for watching. Let us know your thoughts below on the matter of expropriation without compensation. Is amending the Constitution, introducing the expropriation bill, all these various legislative avenues, really the best way to pursue restitution and equitable and effective land reform in South Africa, or are there other avenues and ways to allocate resources that might be better spent? Until next time, this has been Chris Hattingh for the Centre for Risk Analysis. Take care.